The live stage here at Great Bend Farm Ranch Expo, Sunday down. Hey, we are here, brought to you by Fenoglio Boot Company, American Hat Company stage. We've been having a lot of different topics, a lot of different speakers throughout the day. It's great to have one that I think has a lot to do with rural America, an important part of farming, ranching, and owning land, and it's about farm leases. And we've got an attorney here to talk about it. So if you're an earshot, you want to come ask some question about leases or anything probably ag-related, we've got the guy to do it. We've got Ty Patton here with the General Counsel and an auctioneer as well, part of the McCurdy Auction Service. And I'm just going to turn things over to Ty, and he's got a presentation and have some questions at the end.
Hey, very good. Thank you. As you said, General Counsel and an auctioneer with McCurdy Auction out of Wichita, Kansas. Been there about 6 years in that capacity. Prior to that, practiced law up in a small firm up in Topeka area. Did a lot of community bank work, a lot of with ag lending portfolio stuff, a lot of estate planning, probate stuff, and real estate transactions. So dovetails real nicely to the hat I wear or the world I live in now. So happy to visit with the crew here today, and those of you who are joining us online as well. Thank you. About Kansas agricultural lease basics. First question, of course, is why does this matter? The best estimate we have is that more than half of Kansas farm or pasture land is rented. There's a lot of landlords, there's a lot of tenants, so this matters a lot. We don't have a great number in terms of what number is unwritten out of that portion, but a lot are. A lot still, even though a lot of your good advisors and your K-State being one of them has been jumping up and down for a long time saying write it down, write it down, write it down. Still a lot of unwritten leases, a lot of handshake deals, and that makes sense sometimes, but there can be some trouble sometimes when we don't understand what that means, or sometimes even more troubling is we think we know what it means, or we know just enough to get ourselves in trouble with what exactly just a handshake deal means, or what's not in there. About 40%, the best numbers we have are not cash leases, but they're crop share, which is again kind of the simplest, 1/3, 2/3 split kind of typical deal. That's when people think of a verbal lease, just your old-fashioned farm lease, that's kind of what people think of. So we're still, like I said, notwithstanding some great tools out there, in a lot of ways, this is an area that's very similar to the way it's always operated, kind of the way we've done things from the very beginning. Okay, so what does it mean when you have a tenant? What do they actually get? There's some of this that makes obvious sense. There's some things we probably haven't thought about. A tenant, when you lease on the ground, you say, here's my quarter section, here's we have a 1/3, 2/3, go do what you're going to do. They have the right to possess the land and use it to the exclusion of anyone else. That includes the landowner, obviously with some exceptions or some rights to the landowner. Your landowner, when you have a tenant, what you can do there, you can go on to that to make reasonable inspections. If there's improvements on there, make sure things are the way they're supposed to be. Make repairs. If you're responsible for fence still, something like that, that's acceptable. If you're getting towards the end of the lease and you've got somebody that wants to buy it, you can come on and make those showings or show it to a potential future tenant or purchaser. You see your guy out on the tractor and he hasn't paid you, you can stop and walk across the field and ask him for rent. That's fine. Or, again, similarly, to deliver the notice of termination, and we'll get into that as to how that works, but those are fine reasons to be on there. What sometimes does trip people up is, obviously you can't interfere with their operation. Tenants on there farming, tenants on there running cattle, what you're doing can't interfere with what they're doing. You can't turn out your own cattle on pasture ground you just leased. The thing that some people don't think about is hunting rights. If you don't, absent any agreement to the contrary, if I say here's a section of ground, out in the Flint Hills, it's yours. I can't then show up there and hunt it, or then say to somebody else, hey, you can go hunt it, pay me $1,000 for a hunting lease. That's something that technically has gone to the tenant now, unless you have an agreement contrary. People don't think about that, and sometimes that's fine with the tenant, but every once in a while it comes up. We had one recently where that was an issue, and no one had ever thought about it because it never come up. Now you have a new owner come in that wants to hunt, and the tenant said, well, no, I charge people for guided hunts every year. I've been doing this for a decade. Landowner just didn't know because he'd never thought about it. So that's probably one area that people don't often think about, are those hunting rights. So, like I said, a big number of leases are just verbal leases, the handshake deal. Kansas law recognizes in courts. Those are enforceable leases. There's a couple provisions there. You cannot, because of the statute of frauds, have a verbal lease that lasts for longer than a year. So you can only have, an unwritten agreement for a year. Anything longer than that would have to be in writing. So a handshake deal for 5 years is technically unenforceable. What Kansas law presumes is those are yearly, and they're just going to repeat perpetually unless something's done. But there are year to year. It's not a 5-year lease. They're 5 one-year leases is what you can do there. And of course, barring any change, and we'll walk through kind of how that would work, you get to the end of that term, they stay on, it just carries over. Nothing changes. That lease will just continue to renew at whatever terms you had year after year after year. They can't be assigned or transferred by the tenant. That's something that you can address in a written lease, but if I had a tenant that's been farming for, again, take that, the one I just mentioned, he's been on there for 10 years, and he says, hey, I'm assigning all my rights, I'm selling out, I'm retiring, and I'm going to assign all my lease rights to my leasehold interest to my new buyer. That doesn't work for a verbal lease. That's not something, unless you have an agreement in writing that permits that, that's not something a tenant can do. Which again, maybe that's good, but if those are things to think through. And another reason to have written leases is some of the things that can come up. Kansas law has a framework for them, but it's pretty simple. They're not necessarily thinking great thoughts, and so the complexities are often not reflected when you just have a verbal lease. So this is a question you get all the time, and it's a question that there's misunderstood sometimes too. How do you terminate this lease? What actually has to happen if you have this verbal lease that's carried over? Kansas, for a verbal lease, and this is true for pasture, this is true for tillable, this is for farm leases, they presume a March 1 to March 1 calendar. That's the year you're working with. So if you're going to terminate, that you're working backwards from March 1. And that's because it's a statutory framework, anything you do has to fit right within the actual statutory framework. There's no kind of close enough under this, because either the notice satisfies the check boxes or it's not a notice, things like that, because this doesn't exist kind of under common law. This is something we've created for this termination. So if you have a tenant, you're going to terminate that lease. Has to be written notice, has to be delivered to that tenant no later than 30 days prior to March 1. So work backwards. That's not February 1. This is something that happens all the time. Well, I did it the first of the month. You're inside 30 days. You've now waited too long. It's 30 now. Why the Kansas legislature didn't just say you have to notice them up by January 28th, who knows? But 30 days prior to March 1. And it has to specifically provide that the date of termination is March 1. That seems obvious, but there's a couple places where people trip themselves up that I'll point out here. And again, it's got to check all the boxes, because this is what the statute says termination looks like, and that's how you do it. So, we have a tenant, we're terminating, we do notice, checks all the boxes we just said, we timely delivered it. What happens? It's done. You did it right. They're terminated effective March 1, assuming that there's none of the other kind of provisions I'll just talk about come into play. So they don't have a fall seeded crop planted. They were going to put soybeans on. And so there's nothing on there. You terminate on January 26th. You did it. You get possession on March 1. Tenant moves on down the trail. Now, let's say if before they got that notice, they've undertaken what the statute calls customary tillage practices, or they've applied some chemicals getting ready for planting. Well, they don't get to stay on necessarily. That doesn't extend their rights, but you at least have to compensate them for that effort, for that time, for their costs. That's fair. That's part of the termination. So they need to get you a bill. You need to pay for that work. You can't terminate someone in January right after they've gotten ready, then come in and plant and take advantage of that work. That's what the statute there is trying to close that loophole. Now, if it's alfalfa, it's a little bit different deal. If it's alfalfa ground and the tenant obtained a satisfactory alfalfa stand the previous fall, then you have to compensate, and this is again language directly from the statute, you have to compensate that tenant for the fair and reasonable value services performed in preparing and planting alfalfa, and then you have separately reimbursement for seed, fertilizer, herbicide, or pest control costs. That kind of more complicated framework is only for alfalfa. But in both of those cases, the actual termination is still effective on March 1. You're getting possession, they're done on March 1. You just may have some costs to settle up on because of the work they've done. Now, let's say they have a fall crop on there. So they've got winter wheat in there, right? And we decide January 1, you know what? We're trying to move on later this year. Well, they've already got their winter wheat on. What happens then? Now, in that case, the lease termination date is construed to be either the earlier of August 1st or the day after they pull that fall seeded crop off, whichever comes earlier. But the actual termination for the purposes of the statute is still March 1. That's odd, but here's how that trips people up and why it's worth pointing out. What people will do on occasion is, you've got that guy on there, you've got a tenant farmer on there, he has his winter wheat on there, you're going to notice him up in January, you know, you're not trying to be a bad guy, that you want him to come back and cut the winter wheat. That's only fair. So you deliver your notice timely, it's in writing, and then it says, hey, you're terminated August 1st or day after you cut, whichever's earliest, and you've tried to do them a solid. The problem is that's not effective notice under the statute because the statute says you have to fix the termination date on March 1. So you're trying to be nice, but you've actually, unwittingly, destroyed your notice potentially if it becomes an issue because technically that did not fall within the statute. So you're still supposed to deliver that notice, say, hey, March 1's your termination date. Then if you want to say in there, you know, because you've got a fall on there, it's going to be construed as, that's fine, but you have to check the boxes still. And so that's frankly kind of a silly outcome, but it's one that could come out to bite you because you're trying to be nice and do the right thing. But again, notice has to be exactly as the statute anticipates it being. So what happens if we don't hit that deadline? Well, we didn't terminate notice, but you say, and this is a fair question, let's say they haven't actually planted yet. They were letting it sit, they were going to put winter wheat on it. So, surely no harm, no foul. Well, no, that's not how the statute presumes that. There's this kind of very complicated structure that then pops in and says, if they've prepared the cropland in conformance with normal practices in any year in which a fall-seeded grain crop has been or will be harvested, then your notice is construed as fixing your termination date as August 1st or the day after harvest the following year, whichever is earlier. So you miss that deadline and you say, well, there's nothing planted. They still get the chance to come in, plant that fall-seeded winter wheat, come back the next year and cut it. So it's the statute does not have a no harm, no foul provision in it, I guess is the long and short of it there. Now that does anticipate that they've already done some work prepared for it to do the kind of the super extension that way, but they've anticipated it. Really, as you step back, if you want to kind of look at the history of this statutory structure, essentially we came up with the very basics of this, the Kansas legislature. And then every few years something would happen which they thought seemed unfair. There'd be some outcome, tenant and farmer would get crossways, some case would come up, the Court of Appeals or the Supreme Court would say, yeah, that's what it says. And if the tenant kind of took it in shorts, they'd come back and bolt something else on, but they've never sit down and just redone this in a cohesive way. So that's why you have the statute and then these little tack-ons periodically, because it's kind of the legislature fixing it. Whether they've done that or not, I'll let you judge, but it does, that explains kind of this piecemeal fashion as they keep come back and right some wrong. Now, I mentioned this earlier, but what if we write it down? You should write it down, candidly. That's a best practice. But what will happen sometimes when you write it down and you have a good intention is then you stop writing it down. Because, well, we had it, it expired, they carry it over. But that written lease can alter that March 1 to March 1 framework even after the written lease is no longer in effect. And so what I mean by that is, let's say you have your pasture lease, it terminates December 31. That was what you guys decided. But that expired, he stayed on, he came back the next year, it's been working great, you're 3-4 years down the trail, you've never signed a new written lease, you're just operating under that old terms. He's a holdover tenant, or that tenant is a holdover tenant from year to year. But when the landowner gets ready to terminate that lease, you say, well, it's a verbal lease, we use the March 1 deadline. Actually, you still have to go back and respect that termination date from the written lease. So termination is not in that case, even though you're a few years down the trail, it's not January something. If you terminate it on January, you've missed your deadline, because it's actually 30 days prior to December 31, because that was the termination date under the original written lease. That's a challenge when you have, I mean, this is very often in, the land that's maybe it's changed hands generations. I'm pretty sure Dad had a written lease with a farmer at some point. No one has seen it. No one remembers. They've just been holding over. That written lease, if it then emerges down the trail, can change what you think is going on. And so written leases are good, but the cautionary tale is there is keep them up to date. Don't do a written lease and then say that's a pain, we'll just let it ride, because that can then, people kind of forget the terms of that written lease, but you need to know, because it stays, can have an impact even after it's expired. That's a very brief overview, and so there's a lot of intricacies to it. The big takeaway is anything we just talked about within reason, all the different frameworks, all the information, almost any of that can be altered by written agreement. So if you wanted a longer term lease, if you want more control over what your tenant's doing, if you want the ability to say, hey, any bull you put out in this pasture gets one chance to wreck my fence, and then I can have him kicked. You can do all that in a written lease. If you want different termination dates, all that stuff, but it's got to be written down. It's the way that I kind of explain this or think about this is in some ways there's no such thing as an unwritten lease in Kansas, because if you have a verbal lease, there's a statute that comes into play that says, hey, don't worry, we'll write this down for you, here's what it is. It's not very good. And so the question is, do you think you'd be better at putting together a written lease than the Kansas government? Because they've got their own written lease they'll use for you. I think most of us would be more comfortable doing it ourselves. But I know that's kind of the general overview. I don't want to turn this into a 3-hour lecture. If there's any questions, I'll be happy to answer those.
Sure. Good question. You talk about the importance. I think it's obvious looking at those leases from year to year or something. Is there something that you recommend? Is this something where a landowner should talk to you in December every year? Is there a certain time you say, hey, let's sit down with an attorney and look at this lease every year? I mean, do you have a recommended time or years as well? I mean, do you look at it every year, or do you look at it every 3 years, and what's kind of about?
I think that makes good sense. And in some ways, I think the time to do that is when you're getting to the end of the year, you're sitting there and you're figuring out, I mean, you're having some conversations about what do my tax implications look like? Do I need to do something at the end of the year? I mean, we have those when you're visiting with your advisors. That to me is the time to do it, because it gives you some time to think about, does this still work? I mean, there's also there's an element to this that if you have a lease, even if you have a written lease in place, and either you as a landlord are losing money or your tenant's losing money, that's not a long-term solution. And so, revisiting that and saying, hey, does this make sense? Are the terms still right? Kind of just by December, end of the year, when you're having those conversations, your year-end planning, your financial planning for the next year, that to me is the time to do it. Now maybe it's just a matter of sitting down with the tenant and saying, hey, everything's going great, let's sign a new one. But your needs change and things like that, and so that to me is the time to do it. But what you should not do is think about this into January and then you're just too late, because you're carried over regardless. Now, if you got a written lease, I guess you may have something different. But to me, it makes sense to kind of sit down and have those conversations when you're looking at your year financially and saying, does this still make sense for me in the next years? Or and I know this is a dangerous, hard thing to do. What's the economic outlook? What's going to go on? What do we think? Do we still feel comfortable with, a cash rent? Maybe we say, hey, commodity prices are so wild right now that it's better for both of us to go to switch this thing now and do a crop share agreement so it provides the tenants some safety. And those are the time to have those conversations when you got time to implement.
So, in kind of, you mentioned too, they automatically roll over. We don't have that discussion. Is it your recommendation to create a new lease every year, you think?
I mean, not necessarily. It's worth revisiting. And maybe it's fine. I mean, if it's not broke, don't fix it. It's a fine mentality. But you just need to make sure that you're comfortable that it's not broke. I think is the fair way to do it. I mean, and maybe it makes sense. I mean, for a 5-year lease or something like that. I mean, that's fine if you want some long-term. You may have a tenant ask you that. Say, hey, I want some stability to know. Have those conversations. And so it's not necessarily that you should never do a long-term lease or never have something that continues year to year, but you should at least do it knowingly. Go into it and make that's a decision you made. Because as an owner, you're going to build some mitigation of. I mean, what if you had your cash lease, and you think back 4 years ago when beef prices just went astronomical. You're kicking yourself that you couldn't go take advantage of that because all of a sudden if you were in a 5-year lease, you're 3 years in, you're way under rented depending on what you can go demand on the market. So there's some risk there that you're going to miss out potentially, and maybe that's fine for stability. But that way you can have some conversation, make some planning about it. You should do it intentionally and not just fall into it, which is so often what happens.
Do you see much difference on the leases that you guys put together? Maybe you can share. Maybe they're really similar, but between crops and pasture ground, is there a lot of difference in the literature that you're putting in, or the provisions, or what do you see different?
Sure. And that's the other thing that I think sometimes scares people about written leases is you can make them as complicated as you want to be. And we've seen this. They're 9 pages, they've got everything in there. Maybe that's best practice, but they don't have to be overcomplicated. What you see. The big difference, I think, what you see in the conversation to have is with your pasture lease is what kind of control are you wanting over herd management? I mean, that's a big piece that is when a verbal lease is not there at all. It doesn't come up in a just a tillable ground. They're going to plant kind of what they're going to plant. Now maybe you want some constrainers to control or some ability to say here's what I want you to stay away from, but with the pasture, the ability to have at least some participation in herd management, to me, is one of the biggest things. Is what do you do when you're looking out and saying they're overgrazing? I mean, this isn't right. Another one that is more specific to pasture is noxious weeds. That's a question sometimes: is whose responsibility is that? Is it the landowners or the tenants to control noxious weeds? And Kansas says yes, it's both of yours. You're both supposed to do it. But at the end of the day, if the county steps in, the landlord's the one getting that bill. And so if you're a landlord, to give that responsibility back is I think, appropriate. And to have some ability to be indemnified, or that's a trigger event for default or something. And that's something that's not going to come up in just farm ground, but in a pasture lease, there's some kind of control elements there that you're going to want to have. And you're more likely to have some improvements that you need to think about too. You got 160 acres and 159 of it's tillable. They're not going to break anything, right? I mean, there's nothing out there. If it's, if there's corrals, if there's chutes, if there's stuff there that who's responsible for that, who's responsible for upkeep, things like that. Those are the things you can think through and control, and probably should be in a pasture lease that don't come up necessarily in just your farm ground. And going back to our earlier point about the way this statute exists, for the longest time they just talked about farm ground, and that became the point of contention is, well, what does this whole framework the state came up with, how does that work with pasture ground? And the legislature looked at it, and rather than come up with any different framework that said, well, does March 1 to March 1 make sense, they just said, yes, it applies to pasture. That was their solution, is just say, yes, it does, and tap pastures on there. And so, to me, the verbal lease structure that comes into play is even more kind of problematic for pasture lease because it just doesn't make sense with how you normally manage pastures.
So what you're saying with that is the importance of doing a written lease. You can change the dates. You don't have to worry about these things as long as you do that.
And it doesn't, I mean, and for pasture, does it make sense to be annual? I mean, do you want something? I mean, you don't need to necessarily. I mean, especially as you look at the Flint Hills, there's not necessarily a reason to lease that from January 1 to December 31. And so you can have a lot more, be more intelligent about what you're doing than you can otherwise if you just let kind of the statute fill in the gaps.
Pasture ground. With now we're seeing a lot more of this drought government programs and things like that. Where do you think that fits in a lease as far as who keeps that government program and so on?
Well, and that's another fantastic, that can become a little bit of a point of contention, and a written lease lets you anticipate that. I mean, the last couple of years were a good example. You had emergency federal money that didn't fit into any established program. Well, a written lease may say what happens to that. And hey, if you can't afford, to make your lease payments, but you went and qualified for this emergency stuff, I'm going to get paid on that. But absent some agreement, I think you have a fight. Now, I mean, rightly, you'd say, hey, I'm supposed to get paid, but if they turn their pockets inside out and say, I can't pay you, you as a landlord, you're maybe getting in line. And go file a lawsuit, get in line behind everybody else, and maybe case equipment finance beats you to it. And so, so that's another kind of consideration to think through and I think what we expect, and anytime we're looking in the crystal ball, it's difficult, but I think what we should expect is there's going to be more different federal programs. I think you're going to see, whether that's some kind of green credit stuff, that you've seen some of that already, whether that's just pure kind of a modified CRP type stuff. I mean, there's going to be more of that out there and it certainly seems like we're going to throw more money at to make it more enticing. And so those are considerations for a landlord, whether you want to participate in that, whether you want your tenants to participate in that, whether you want the flexibility to say, hey, I'm pulling out of this thing because the government will pay me to do nothing with it for butterfly habitats. I mean, those are some considerations. I think those are going to become more pressing in the next few years. It certainly appears.
Sure. Last thing here, unless there's somebody else who's got a question, but what's your process? You guys work with, your role with Green Auctions. These leases are obviously important. What's kind of your service to the landlord or the tenant on these leases?
Sure. And there's a lot of ways to go about doing that. Any of your attorneys that you're talking about that are advising other stuff, and I would encourage you to visit, when you're talking about whether that's how you're structuring your ownership, how you're structuring your, we visited that a little bit before, your capital gains, your transitions, all those things. Any of those attorneys can help you with this, and this isn't reinventing the wheel. These are out there. Even if you don't, want to talk to a professional advisor, there's some very good resources available. K-State's a good example. Their ag manager has, they'll as detailed as you want. A lot of your, a lot of your extension offices. There's some very detailed leases that are, and like I said, they're, probably more detailed than you need, but at least they're a great starting point. So even sitting down with one of those, just filling in the gaps, tenant landlord, is probably better than just not ever having a conversation about it. But these don't have to be overcomplicated. And so we've got people we know that do a good job that we can plug in. We've got some examples that we can provide to people that we've seen. Like I said, there's a lot of resources out there. This isn't a new conversation. We've been having this conversation for a long time, and certainly there's been, as we've got more sophisticated in a lot of the things we do, we've made some progress. But some of these resources have been out there for a long time. K-State in particular has been beating its head against the wall and knows, hey, write it down, write it down, write it down. So they've got some fantastic resources there.
So the process would be give you guys a call. Hey, help me. I'm trying to figure this out.
Sure.
And push you in the right direction.
Yep, absolutely. That's one of the benefits of what we get to do. We work all over the state, into Missouri, Oklahoma, Colorado. We've seen a little bit of everything, the good, the bad, and the ugly. And we've been doing that for almost 40 years. So over that time, we'd like to think we've developed a pretty good bank of resources to point you in the right direction. It's not something we can't help with, and sometimes we got to thread that needle of here's our role and here's where you need independent advice. But we can always point you in the right direction, and we can hopefully point you to somebody that's going to do it right because we've seen it and know what they're doing, and we can have some confidence that we're giving you good advice as well. So yeah, we're always happy to visit and be of service on anything. No matter how odd the situation may be, it may not be the first time we've visited about it.
Last thing here, tell us about the company and where you guys are located, all that type of stuff. What other services that you guys
Sure,
provide?
absolutely, appreciate that. McCurdy Auction, we're out of Wichita, Kansas, is our headquarters. We've almost 40 years there. As I said, real estate is really our specialty, and we've do a lot of farm and ranch, but we've got divisions that focus on kind of the investment, whether that's single family, multifamily, that type of deal, commercial, just your bread and butter owner occupant, even a premier or luxury division that focuses on that higher end stuff. And so kind of the specialties to tackle anything that comes up. Still do a lot of farm and business liquidation as well on the personal property side. Like I said, we've seen and done it all, and have worked really hard to continue to build a team and the resources to have these specialty kind of knowledges to do everything and treat it right and do it right. So, kind of like I said, without much exaggeration, really anything you're thinking on, we've got a resource for that. We've got some people that specialize in that, and we're happy to tackle it. Perfect.
I want to thank Ty with McCurdy Auction Realty, so much more. Legal counsel with them. We'll try to get some stuff put to our Facebook page as well, so I can get a hold of them. But appreciate you speaking with us today here at the live stage. Great Bend Farm and Ranch and Hemp Expo.
Thank you.